As a writer and as a lawyer, I have experienced reading a lot of pleadings or a lot of lawyer work that has a lot of unnecessary words or antiquated words. And it's never really a good thing to have it, no, in your legal documents. So, when can we use the tips that I'm going to give to you today? Well, actually, in everything that a lawyer does, from writing a pleading, like writing a legal opinion, or even in writing a book, so that people will understand better what you're writing about. So the responsibility of a lawyer does not end in giving a legal opinion. That legal opinion or advice must be understandable to the client. And it's always very good to practice giving such opinions or explaining such legal advice in a language that can be best understood by your clients or your target audience. So, like for instance, in writing pleadings, okay, what you have to remember is that the judge is already knowledgeable. You have to assume that the judge knows the law. So, insofar as legal terminology is concerned, of course, you need to use the proper legal terminology. Okay? However, beyond legal terminology, right, use words that are simple enough to understand. Also, it's very, very good to practice using different lengths of sentences in your pleadings. So, sentence structure wise, first of all, it has to be, of course, I forget, but it has to be grammatically correct. You have to ensure, of course, the basic is that there are no typographical errors. Okay, important yan. No? It's very basic, but in a lot of pleadings, even in my own pleadings when I review it, when I write it for the first time, there are so many grammatical errors or misspellings. And it's very important for any lawyer to always practice to review their first draft. When you write anything as a lawyer, always think of your audience, assume that your audience cannot easily understand. Have a simple outline in mind, okay, to be able to explain the legal terms that you are actually using to avail of whatever prayer you are asking of the court. So how do you do this? It has to be a balance all the time between knowing what you want to say and actually saying it in terms that the judge will agree with you. So you have, for the first part, you have to have researched well enough to know what legal jurisprudence, what is the law on that matter, and make sure that you really understand it well. Make sure that you avoid antiquated terms, and just go straight to the point. That would be better for the judge. This can also be applied to legal opinions. And in particular, it's very tricky to write legal opinions because you have to really assume that your target audience, the one who will read your legal opinion, is not very familiar with legal terminologies. And so when you write a legal opinion, it's always good to first state the problem, okay, or the inquiry, the issue. Okay, state the relevant laws and jurisprudence if there is. You don't have to write down the entire jurisprudence or to indicate it, but you can just say in several cases already that has been decided by the Supreme Court, this is how they tackled the issue that you presented to us. Okay, and then it's always nice to be creative. Okay, so that's my second point in using your knowledge of the English vocabulary or Filipino vocabulary if you're writing in Filipino. Why? Okay, the usage of words is very powerful for a lawyer. It's a very powerful tool. If you have a good command of the English language and your vocabulary is extensive, you will be able to use words that are more effective in transmitting the things that you want to transmit to your target audience. So in my case, in writing my book on e-notaries, because I know that the original law is quite long and complicated, what I did was, since I'm a notary as well, what were the important points in the law that I could distill in a very, very short pamphlet so that when a lawyer refers to it, to my book, then he or she could easily find what he or she is looking for. Okay, so the same goes for pleadings. You want to be able to direct your the judge or the opposing counsel, for that matter, to your point precisely, and strengthen that point. And you can only do that if you really know your argument well and how to present it well. As lawyers, we must remember that it is in the clarity of our statements that a deeper understanding of the issues, whatever they are, come out. Okay, and ultimately, in any litigation, in any corporate dispute, in any legal matter, that is what is most important. And we can only be effective lawyers if we are able to make sure that the legal opinions that we give, the pleadings that we write, or the books that we write are understandable, concise, complete, and correct.